For this module, we are going to be discussing law and ethics in digital media, multimedia. I'm going to talk a little bit about law and ethics and digital multimedia. This is one of those lessons that if you have the opportunity to discuss with somebody else, either in the class or just someone else you know, it does increase the interest in this area. Okay, first let's discuss copyright. So copyright refers to the legal protection for people who express ideas or information in a variety of forms. The term copyright literally means the right to copy works by other people. And to be copywritten, an idea must be converted into a physical form. So what is a copyright? It's intellectual property is a legal concept that protects a creative work just as if it were a physical property. You're going to end up having a copyright notice, which would include the date and the name of the copyright holder. It is not necessary to place the copyright notice on a creative work to make it legally protected. The way this works is that any artwork that you can, or any creative work that you can prove belongs to you, is considered copyright at the moment of creation. It used to be that whenever you were interested in copywriting something, you had to package it up and ship it to the copyright office in DC, and you had to pay a fee, and that they would copyright it for you, and it would come back with their copyright notice. It is now up to the person creating it just to make sure that it's in some sort of physical form and that they can prove that it belongs to them. So copyrightable works include the following categories. So it can be musical, dramatic, motion picture, pantomimes, choreographed works, pictorial, graphic and sculptural works, sound recordings, architectural, and literary. To use a copywritten material, you need to gain permission. You simply need to ask to obtain permission from the person that owns the copyrighted material. A lot of times this is done in writing, and by putting it in writing, it does protect both parties that are involved. A royalty is a fee that's paid to the person who owns the copyright on the creative work when it's used by someone else. So you're paying a fee to use the copywritten work. A good example of this is Ariana Grande when she created the album that contains the song 7 Rings. The song itself was created off of a famous piece of music, and she wanted to use it. So she made an agreement with the composer that she could use the song, but she had to pay a royalty. She ended up paying most of the money that she made from the album itself to the royalty for that one song alone. Royalty-free is a type of licensing agreement that gives the buyer almost unlimited permission to use the copyrighted images for a one-time fee or no fee at all. So it just depends on the deal that you make with the person that owns the copyright. I have attached this video to the module. I would ask that you stop and watch it if you didn't already watch it. It talks about why Happy Birthday is protected by copyright and how it's protected. Are copyrights needed? If there were no protections for creative works, do you think that people would still produce movies, publish music, or create software? What about, would artists paint or would writers write if their work was not going to be protected? Would you be more or less willing to be creative if you knew that your work could be used without your permission? Okay, next we talk about trademarks. Trademarks are a distinctive word, phrase, logo, or image used to identify something as a product of a particular business or organization. So when we're talking about trademarks, we're talking about things like the Nike swoosh, or Just Do It, or for McDonald's, it's the Golden Arches, or I'm Loving It, or I believe is what it is. Okay? It automatically conveys the identity of the organization it represents. They don't need to be registered to be protected from use for others without permission. So it's just like having copyright as long as you can prove it's yours. But registered trademarks carry the little R and the circle symbol, while unregistered ones use the TM symbol. These are administered by the United States Patent and Trademark Office. Things that go into public domain. So the term public domain refers to creative materials that are not protected by intellectual property laws such as copyright, trademark, or patent. The public owns these works, not an individual artist or author. Anyone in a public domain work anyone can use a public domain work without obtaining permission, but no one can ever own it. So a lot of times, once something has become into public domain, you're going to see that kind of concept or idea repeated. There are 4 common ways that works arrive in the public domain. The first is the copyright has expired. So it was copywritten, it is no longer copywritten. The second is the copyright owner failed to follow copyright renewal rules. So again, just a different way of saying it, it has expired and the owner no longer owns it. The copyright owner deliberately places it in public domain, known as dedication. So sometimes you'll see this after people pass away, that their copyright will be dedicated and will then go into public domain for anyone to use. Copyright laws do not protect the type of work. So there are types of work out there that copyright cannot cover. Fair use. Fair use is the right to reproduce a small part of copywritten work for educational or other non-for-profit purposes without having to obtain permission or pay a royalty fee. So you're going to see this more as in there is an education clause so that you can use items in as long as you're a student and you're not making profit off of them. So if you're doing research or creating artwork, you'll also see this with not-for-profit companies, that they can use things that they find, and as long as they're not making any profit off of them, they can do that. One of the biggest examples I can give you right now is with the whole Friends revival and everybody following along with that. A lot of high schools created t-shirts that look like the Friends logo, but using the name of their school instead of the word Friends. That is allowed just because it is for education and it's a non-for-profit. 4 factors in determining fair use. First is the purpose and character of the use, including whether such use is of commercial nature or is just for nonprofit educational purposes. 2, the nature of the copywritten work. Is it fiction or nonfiction? 3, the amount and sustainability of the portion used in relation to the copyrighted work as a whole. And 4, the effect of the use upon the potential market for or value of the copyrighted work. Number 4 comes into play a lot with one of the major companies in the US, which is Disney. Disney is very protective of their items, even in educational and not-for-profit use. They want to make sure that whatever people are using of theirs is being used in the way they want it to be used. For example, there was a father whose young son passed away from cancer. He reached out to Disney and wanted to put Spider-Man on the headstone of his son's grave. So it wasn't being used for commercial nature. It was simply for his son's headstone, and Disney declined it because they did not want the effect of this to be negative on their company, as being seen as Spider-Man being seen as death and being on a headstone. Plagiarism. Plagiarism is copying or otherwise using someone else's creative work and claiming it as your own, usually in academic and journalistic work, but also more recently in social media. To avoid plagiarism, document the source of your material. This is where that cite it page and documentation comes into play a lot. It is not enough to cite the source of copywritten materials to avoid copyright infringement. You'll see this a lot in YouTube videos when people use music by a famous musician or by other artists. They will have on there that music, the music is not mine, it belongs to, and they'll put the person's name on there. You cannot use copyrighted material in your own work except under fair use guidelines without the owner's permission, even if it's properly cited. Using proper web citations. The 5 basic components of a proper web citation is author, date, title of article, access date, and URL. Deep linking is citing a web address that goes beyond the home or entry page. So you need to make sure, even outside of like language arts classes, you need to make sure you're keeping proper website source citation, as well as any kind of citations that you need to make, so that if your work was ever considered infringement, you can state where you get all this stuff from. Illegal file sharing. File sharing is a useful means of transmitting information from one computer to another. The term file sharing has come to mean the illegal transfer of copyrighted materials between computers, and it's a form of copyright violation. One of the biggest examples of this is piracy. So piracy is when you're copying a product, often digital, for profit without authorization from the owners. These are the icons that you're going to see at the beginning of movies, videos, where it's talking about the anti-piracy warning. Copyright. So some examples of copyright that have happened in media within the past few years or recently. First example is the Associated Press versus Ferry. So back when Obama was starting out his campaign, many of you may have seen this poster or ones along the lines of it. Ferry was an out-of-work graphic designer that was doing some freelance work, and he was home one day and he came up with this idea for a poster to support his choice in the campaign, which was Barack Obama. He created this poster all on his own. He Googled an image, found it, and created on top of it. He then printed off the posters and took them out on the street and sold them for, I believe, $2 a piece. When he was contacted by the campaign to use these posters in the actual campaign, and he agreed to do it. It was at that point that a photographer for the Associated Press realized that it was his photograph that was being used in the posters. So the Associated Press sued Ferry for infringement based on this image. So you can see that the image on the top line of this example was the original image that the photographer took, and you can see how it lines up perfectly with the posters. So after Ferry got sued, he admitted that he went on Google and he found an image, but he swore that it was the image that's on the second row of this example. And you can see how the images do not line up. So that's how they were able to prove that Ferry used this image. And he was sued, and the Associated Press won. It did go back to court another 2 times, in which Ferry won once and the Associated Press won again. They ended up coming to an agreement that they would share the copyright on it, and No information was ever released on exactly what the settlement was. Carol M. Highsmith versus Getty Images. So Carol M. Highsmith was a photographer, and she took all of these photographs and she put them into the public domain for use by people that just wanted to use her photographs. Getty Images came along and began selling the photographs that Highsmith had put into public domain. Highsmith didn't want the images to be for sale. She wanted them to be free to everyone, and she sued Getty Images. Getty Images ended up winning the trial because of the fact that she did put them out there and said they were for anyone's use, and she did not put any kind of stipulations on the fact that they could not be used for commercial purposes. Rogers versus Coons. So Rogers is a photographer that took some photographs. Coons is a sculptor. He began using Rogers' photographs to create, he used this photograph by Rogers to create a sculpture. Rogers sued him, and Coons did lose copyright because of it. Here's an example of audio copyright that I am going to post the video into the module since it won't link well from the PowerPoint so that you can watch it. It talks about Vanilla Ice, who sang Ice Ice Baby, and how he considered his sampling to not be copyright infringement. Trademarks. So trademark examples. So here is a whole page of a lot of trademarks you've probably seen somewhere along the way. So as we talked earlier, trademarks can expire. They can also be considered generic. So trademark examples that are generically used by customers, but actively enforced by their owners against use from other brands. So for example, one of the biggest ones you're going to hear now is if anybody edits a photo in anything, it is now being called that it's been photoshopped. Photoshop is actually a brand that's put out by Adobe, but it's a term that's being used generically. You also have the term Band-Aid. Band-Aid is a brand owned by Johnson & Johnson. It's the generic name should be adhesive bandage. You have Frisbee. Frisbee was the brand's name. The generic name for it is a flying disc. And then chapstick is owned, trademarked, and is a generic name of lip balm. The next set of trademarks have lost their legal protection because they became such a common name of a product or a service. So kind of back along the lines of the Photoshop right now, it's being so popularly used, whether or not it could someday fall into this category is a question that they have. So the first image, the trademark owner was Dry Ice Corporation of America. It's a solid form of carbon dioxide, and people just began calling all of them dry ice. Aspirin, videotapes, and escalators also fall into this category. The Otis Elevator Company originally trademarked the term escalator for its moving staircases, and it became known as all of them being escalators. Okay, the third area of this is when former trademarks that lost legal protection due to abandonment, non-renewal, or improper insuances, sorry. But two of them on here are both owned by Apple. So when Apple first developed the app and the App Store, they realized that people were using it as an overall like umbrella term for all applications that were being made for phones and laptops that they ended up canceling and abandoning them so that the App Store would be just a generic term now. Okay, we also have zippers and yo-yos. They were both terms that were just so overused that their companies decided to no longer use them. Trademark cases. So an example of a trademark case would be Starbucks versus Exit 6 Brewery. Exit 6 Brewery is here in the St. Charles area, and they came up with a beer called the Frappuccino Brew or something along those lines. Starbucks actually sued them because a Frappuccino is trademarked by Starbucks. If you ever go to somewhere like McDonald's, you can order a frappe. It's the same thing, but they cannot use the term Frappuccino. One of my favorite trademark cases is the Ohio State University trademark case. Ohio State decided that there were too many OSUs and they wanted to make themselves different from all of the other OSUs. So instead of trademarking that term, they trademarked the word the. So now on any of their school merchandise or anything of that nature, it's the word the that showcases the Ohio State. Two other big trademark cases or celebrity cases are the Taylor Swift's 1989. In this case, she did select different words off of her album and trademarked the words themselves. Some of them got trademarked, some of them were denied because they were so common of a word, they didn't feel it was right for them to trademark. Tim Tebow trademarked his T-bowing. If other athletes are caught doing this on the field, he does sue them and can win the trademark case because he owns this exact stance. Ethics. Okay, fair warning, this gallery contains some graphic images that some viewers may find disturbing. So media ethics is the subdivision of applied ethics dealing with the specific ethical principles and standards of media, including broadcast media, film, theater, and arts, print media, and the internet. The field covers many varied and highly controversial topics ranging from war journalism to ad campaigns. Media ethics has come into play a lot over the past 5-6 years, especially with Donald Trump being in office. He did have a lot to say about different media ethics, and it became clear that it was something that needed to be further looked into. Okay, so ethics, it's a personal choice versus a professional responsibility. There are different foundations of ethical decision making. The first one is the utilitarian, the greatest good for the greatest number of people. It recognizes that media provides information critical to the democratic society. It is right to take and publish. By publishing, it could decrease the number of accidents. So they believe that if they do something, it's for the greatest good for the greatest number of people. Absolutist, people have the right to privacy. They think that the greatest good bumps against the competing ethical principle that says there is a certain principle that are fixed, like thou shalt not kill. And invading privacy, regardless of the social benefits, is unacceptable. The third set is going to be the golden rule. Do unto others as you would have them do unto you. You do what you believe is right or what the other involved would believe was right. And the problem is you don't really know what the other person feels. First example I have on here of ethics examples. As I'm talking about this, I'm just going to put those ideas out there. I'm not going to say whether or not I feel they're right or wrong, or whether or not you should feel they're right or wrong. I want you to think about what I'm actually saying and how these would affect you in ethics when it comes to media. So the first one is a photographer was known for taking these photographs. He took the photograph on the left. He published the photograph on the right. It is the same photograph, but he made color adjustments to it. The argument came out that he is a documentary photographer and he should not be making color adjustments or any kind of adjustments to any of his photographs, because documentary photography is about documentary and photojournalistic photography is about telling the truth, and what you see is what you get in your images. He stated that all he did was make these slight color adjustments, that it didn't change the images themselves. These are other pieces of his work. His name is Steve McCurry, if you're interested in his work. These are other examples of his work. Do you see a problem with him using color adjustments in his work to show the world what he sees? The next example of ethics is with color adjustments are these two images that came out of O.J. Simpson. When O.J. Simpson was tried for murder, there were countless numbers of covers. There was countless numbers of covers and of stories being put out there by him. And a lot of the images used his mugshot, which is the image that's being used in these images, or in these covers. So the one on the right is by Newsweek. Both of these magazines are considered to be news article based publications, but does one of them appear to be more for entertainment than the other? Is one of them trying to tell a different story than the other, just through their color adjustments? And is it right or wrong to use those color adjustments to tell the story? Okay, the next set is under embellishments. So for this article, it's another image taken from the O.J. Simpson trials, and the photo is of O.J.'s wife, Nicole. The Inquirer is known to be a more entertainment paparazzi type of publication, and they admitted to taking the photograph and embellishing it and darkening the bruises on her face, because in the photograph they could not be clearly seen. Do you feel that goes against the media ethics to improvise or embellish what is being seen in the photograph? Slicing images. So for this image, the image on the right is the original image. The image on the left took the original image and put Oprah's face onto it. Oprah did not know that the image was being used. It was completely done by TV Guide. The original model did not know. The way they found out was the original model's manager saw the TV Guide. The dress had been specifically made for that model and had never been recreated, so he recognized the dress. Oprah was not happy with the whole thing, especially with the fact that she had gone through so many changes and she was dealing with so many self-esteem issues with her own appearance, that she was very unhappy with TV Guide. But TV Guide wanted her to look a specific way. Does this go against ethics? Perception. So for this image, the photographer took the photograph. He was a photojournalist, and this was during the Vietnam War. One of the rules with photojournalism is that you cannot, not that you cannot, that you should not show a person dying. You can photograph the person before and you can photograph the person after, but then photojournalism, you don't photograph it during dying. So the argument has been out there that there are multiple perceptions of this photograph. There are people that think that it's before he got shot. There are people that believe that he did get shot and he just hasn't collapsed yet when the photo was taken. And others believe that the photo was already after he had been killed, but he had just not collapsed. So how does perception play into this? This photograph was this photograph was used to turn Americans against the war in Vietnam. And so people were using the idea of this photograph as one way, even though it was taken in another. So does perception play a role in ethics? Privacy. So back to those three areas of privacy, you have people that think that it's for the greater good. You have people that think that there should be a sense of privacy. So with this image, the image is of a young boy that was that had drowned out with a day with his family. This image was actually used in a publication to promote whether or not drowning should actually take place and how to prevent drownings. Many people said that it was not the correct image and it was invading the privacy of the family, even though they were on public property to show this child. Do you think this image should have been used? Okay, responsibility. This image plays a huge part in the whole argument over war photography and photojournalism. So this image was taken in Africa during an African war. The photographer, along with 3 other photographers, were in the area shooting and photographing everything that was going on. He took this photograph and it ended up winning the Pulitzer Prize. When he came back to the US to do a tour and talk about the photograph and the prize, he got a lot of questions about, well, what did you do? Did you chase off the bird? Did you save the kid? Like, what happened to the kid? Where's the kid at now? And he said that according to his job was to be a war photographer, a photojournalist, and it's to go out, get the picture, and leave the scene the same way he found it. He did not chase the bird, he did not save the kid, and he took a lot of backlash for that. His response was that if he would have picked up the kid and taken the kid back home to the village, everybody else in the village was starving too. The child would not have survived it. That if he shoot away the bird, that you can only see the one vulture in this, but there were 10 or a dozen more vultures around him that you can't see in the image, that shooting off one bird was not going to save the child's life, that he did not feel that it was his professional responsibility to do anything other than to take the photograph. Do you think that personal responsibility versus private responsibility should play a role in this? This is another thing that's happening right now a lot on social media, is you have influencers using products to, or using social media to sell products and make money off of it, even though they are faking the situation. So these influencers are not really in the locations that they say they are, or they're not really using the products that they say they are using. So their reality versus what they are showing in their imagery is two different things. Do you think that social media needs to show more of what's really going on, or do you think it's okay that they use it almost as an advertisement and the true reality does not need to play a role? Public versus private. So another social media one, since social media is so big in our lives now, there was a gentleman that went to New York and he took a photograph and posted it on his social media. And there's two different stories of this. The one that's on the screen, they're basically the same type of story, but just slightly changed depending on the store that you're talking about. So in both situations, it was a gentleman that went to New York, was photographing, posted images on their social media. Images were taken off of the social media, in one case by H&M clothing store, and the other example, it is by Kenneth Cole Shoes Company, Kenneth Cole, the designer. In both cases, their imagery was used to make other products without their permission. Should companies be allowed to use images off social media without the person's permission, or is it a case of the person creating the images, putting it out into a free domain type of area by putting it onto social media? And the last one, I include this one because this was actually done to one of my students. He decided to go to a Trump rally that was held here in St. Louis and photograph. He is a documentary photographer. He shoots a lot of different documentary events, kind of like he covered some riots before. He's covered funerals of veterans, but he decided to go and cover the Trump rally. And while he was there, he took a photograph and he posted it to his Instagram page. Trump's campaign then took the photograph and began using it as one of their campaign photographs. They did not have permission, but they did remove it off social media, so they were using it as their own. Is it acceptable for people to, again, pull images off of social media and use it for their own profit? That is the end of the law and ethics section. If you have any questions, please shoot me an email and I will get an answer for you.